Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for watching. Today on the docket, number 1, Kim Kardashian. Number 2, let's talk Miranda advisements. And 3, Patrick Frazee update. The court has given a written order on the motion to suppress his statements. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in today. We have a lot on the docket, but first I want to say thank you to everyone who went to our link and purchased mugs. That was the big hot seller. Apparently, some people had issues with the link. Teespring says you may not have plugged in the proper discount code correctly of Crime Talk, one word, all caps, and because there was some confusion on that, we're going to extend the sale with that code until the end of next week. So if you want a mug, you want a shirt, you want that jersey, hit the link below and go there. Also, the Patreon page is just about ready to go, and when it is finalized, we will let you know. We think that there'll be some great incentives on various tier levels for people who would like to contribute, and I'm certainly going to do everything I can to make it worth your while to make sure that you receive value. So let's get to the docket today. Kim Kardashian. Yes, we all know Kim Kardashian. Some people love Kim Kardashian. Some people hate Kim Kardashian. But sometimes everybody watches Kim Kardashian. And I don't remember what it was, if it's the Bravo or the E channel, but it seems like everything on one of those channels is nothing but them or the relatives of her, the ex-boyfriends or somebody. But I'm not going to lie. I do like the Flip It with Disick show that's on there. Somehow I think it was related to one of the sisters, but I don't know. But I digress. Kim Kardashian wants to be a lawyer. Hats off to her. California is one of the jurisdictions where you don't actually have to go to college and law school to become a lawyer if you can actually pass the test. It's rather rigorous, and it only has a pass rate of about 24% of really kind of the first year bar exam, where you have to show that you have a general understanding of the subjects before you can go on and continue your legal studies without going to a law school. I encourage, like I discussed the other day, go to law school. You don't have to pay $100,000 for that Stanford education, that Harvard education. I can tell you, in 25 years, no one, not even other attorneys that have hired me or referred me cases, have ever said, I am hiring you because of the law school that you went to. It doesn't matter. Yes, you want to go to a good school. You want to go to an ABA accredited school. Don't get me wrong. But they're all the same, and only thing that matters at the end of the day is that you pass the bar exam. So if Kim Kardashian can do that, hats off to her. It's a tough program that she's trying to do. She has the assistance of a law firm in San Francisco that is willing to help her. And the reason why I bring this up is that she put out a tweet this weekend that she wasn't going to be able to do much of family entertainment and has actually missed various social media obligations that she was required to do because she is studying as hard as she can for the bar exam. It looks like she may be able to take the test in sometime in October of this year for the first year so that she can show that she's ready to go. And Kim Kardashian, Crime Talk here, if you get to criminal law or you get to torts or evidence and you need some help, let me know. We're here for you. If there's one thing I know, it's criminal law, torts, and evidence. I can summarize it all for you in one sentence or less to make sure you understand the key concepts. So, Kim, call me. Now, next on the docket, I want to talk about Miranda rights. One of the questions that I get asked most often is, I was arrested and nobody advised me of my Miranda rights. And then the next question I have to ask the client or potential client is, were you in custody? No, I was on the phone. Or they came and arrested me and took me away and they didn't answer me any questions. Okay? Miranda rights and just let me give some historical context. Miranda v. Arizona is the case that brought about Miranda rights. And just by way of background, this was a 5-4 plurality decision from the United States Supreme Court in 1966. But the facts behind the case, I think, are significant, which will help people somewhat understand how they ultimately got to their decision in Miranda. On March 13th, 1963, Ernesto Miranda was arrested by the Phoenix Police Department based on circumstantial evidence linking him to a crime against an 18-year-old woman. After a 2-hour interrogation by police, Mr. Miranda signed a confession to the alleged crime that included a typed statement that says, "I do hereby swear that I make this statement voluntarily of my own free will with no threats, coercion, or promises, immunity, and with full knowledge of my legal rights, understanding any statement I made may be used against me." However, at no time Miranda was told of his right to counsel. Before being presented with the form of basically the confession, Mr. Miranda did not know that he had a right to counsel. He was not aware of his legal rights. He was not aware that he could stop the interrogation at any time. And therefore, his lawyer, who was a court-appointed lawyer at the time, zealously representing him. This was kind of before the public defender system was set up in 1963. So more likely it was an attorney that was sitting in the courtroom, and the judge said, "I'm going to appoint you to this particular case." The state, or at the trial court level, his attorney challenged the voluntariness of the statement, and the judge denied the motion. Mr. Miranda was ultimately convicted at trial, received a 20 to 30-year sentence in the Department of Corrections. Mr. Miranda appealed, went through the state court appellate process, and it was both denied. They filed a writ of certiorari to the United States Supreme Court, and the United States Supreme Court heard the case. It was a 5-4 decision, so it wasn't particularly overwhelming that the court unanimously agreed and said, "Oh yeah, everyone should be advised of what is now considered modern Miranda advisement." And the case was, or the opinion from the United States Supreme Court was delivered by Chief Justice Earl Warren at the time, who's a former prosecutor. And he wrote that and said that the person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with a lawyer and to have the lawyer with him during that interrogation, and that if he is indigent, a lawyer will be appointed to represent him. Sound familiar? Sounds like the modern day language of Miranda advisement, does it not? Or real close to it? Well, that was written in 1966 by the United States Supreme Court. And in that opinion, the United States Supreme Court also made it very clear what must happen if a defendant chose to exercise his rights, particularly to remain silent or to request a lawyer. If the individual indicates in any manner, at any time prior to or during questioning, that he wishes to remain silent, the interrogation must cease. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any subsequent questioning. Now, I can tell you that if an attorney is requested, that attorney is going to advise the defendant not to make any further statements. Because as I tell clients all the time, anything you say to the police can and will be used against you, taken out of context, misconstrued, misinterpreted in any way possible. Don't do it. So ultimately, Mr. Miranda wins his case. The case is sent back to the state trial court in Arizona. And this particular time, on the retrial, the state prosecutors did not use the confession from Mr. Miranda because the United States Supreme Court said you couldn't. So what did they do? Remember what they said, ladies and gentlemen. Miranda advisements are if you are being advised to make statements to the police. Doesn't apply to everybody else. So the state prosecutors then brought in the woman who said that Mr. Miranda confessed to her. Okay? Not a Miranda violation, not in any way. No government action. And under the rules of evidence, it is an admission by a party opponent. And which also means is that anything that you say to anyone about an issue is potentially admissible against you. So Mr. Miranda made the mistake of not only telling the police in his interrogation, but he told somebody else of what he had done, and that ultimately got him convicted. So in 1967, the retrial is complete. Mr. Miranda is sentenced after he's found guilty. He gets, once again, a 20 to 30-year sentence in this particular case. He appeals all the way up to the United States Supreme Court and gets no love whatsoever. They refuse to review his case in any way because, frankly, there wasn't anything of legal significance there. Ultimately, Mr. Miranda gets out, makes a few dollars as he gets out, signing autographs for police officers' Miranda cards that they carry around that are being issued to police departments all over the country. Now, the true irony of this particular situation is that in January of 1976, Miranda, who's been paroled, he's doing his thing, gets in a bar fight, gets stabbed, and actually dies. The true irony of it is that the person who was suspected of killing Ernesto Miranda was never charged. Why, you might ask? Because he exercised his Miranda rights and kept silent. Okay? So after the Miranda warnings, police officers were basically told if they arrest somebody to advise them of these Miranda rights. They didn't have to do it unless they were actually questioning somebody that was in custody, and it's custodial interrogation. And as we've all seen in the movies, it seems like everybody gets arrested, they immediately read their Miranda rights, and they do that like somehow it's automatic, which is why people believe they need to be advised of the Miranda rights every time that they're, in fact, arrested. All right? Now, an arrest doesn't necessarily mean the only way it is in handcuffs. That's certainly arrest, but it can also be a simple detention based upon officer safety issues. So it's actually a very complex area and is very factually driven in each particular case, which is why people need an attorney to look at those types of issues. Now, back in 2000, a case came up to the United States Supreme Court basically saying that there was no constitutional right to be advised of your Miranda rights. Nowhere in the Constitution does it say that these Miranda rights exist, and therefore a 7-2 court ruled that, although not constitutional, that once again the Chief Justice issued the ruling and said that we are not going to get rid of this. Yes, there's nothing in the Constitution that says a defendant is entitled to know these things. And frankly, if you don't go and read the Constitution, you just are playing out of luck. But let's face it, most people don't read the Constitution. Most people have never read the Constitution. Most people couldn't tell you the first 10 amendments or the Bill of Rights to the Constitution. And so to think that everyday citizens would know those rights, no. And so the Chief Justice, then Rehnquist, said that no, we are not going to get away with Miranda rights or say that police do not need to give Miranda rights because the Miranda rights were so ingrained into our society. It was a little curious that the court, who should simply be there to call balls and strikes, not create law, gave this advisement, and then it really became what people believe to be the law. And no one wants to take away somebody's individual rights if they don't have to. And that's really what the Supreme Court did on that case in 2000, which was the Dickerson versus the United States case. A couple of quick caveats, because someone will always try and get around the rules. But there was a case called Missouri v. Siebert. And in that particular case, the United States Supreme Court heard the case. It went all the way to the United States Supreme Court. And what the Missouri police were doing was deliberately withholding Miranda warnings and questioning the suspect, hoping then to obtain a confession. Once the confession then was obtained, then they go in and say, okay, fine, let me give you your Miranda rights because you've said a couple of things, and let's just go over all that again, and then the confession would, in fact, be valid. The Supreme Court said, oh no, police, you're not going to play those games. If somebody's in custody, you are going to advise them of their Miranda rights. And it's routine, ladies and gentlemen. And here's the thing. Most people will sit there and talk, or they'll say, I just want to find out what's going on. And next thing you know, I've had clients that say, oh, I didn't say anything to the police. I'm like, all right, well, let's sit down and let's watch this 45 minutes of nothing of what you said. Okay. And it's usually not good. So there's also a case in 2010 called Burgeis v. Tompkins. And in that particular case, the Supreme Court said that although you say you want to exercise your silence, you don't have to say anything, you can just sit there, and that they could possibly use that against you. So you have to actually say, I want a lawyer. I want to not make any statement. It must be clear, concise, and unequivocal for that to take place. So little word of advice out there, not necessarily for anybody, but whether you're a police officer, if he doesn't make that unequivocal statement, if he hems and haws and says, well, maybe I'm thinking about it. I had cases where they said, I think I would like an attorney. Not unequivocal enough, according to at least one judge here in the state of Colorado. It has to be, I want an attorney. So I think, hopefully, that gives you some background and context as it relates to Miranda v. Arizona, which is the seminal case as it relates to that, hence the name Miranda warnings. But just the other day, the Patrick Frazee matter, there was an important ruling that came out. For those of you who are not familiar, the Patrick Frazee matter is a matter currently pending here in Teller County, and it's regarding the disappearance of Kelsey Barrett, who has not been seen. Mr. Frazee is charged with the disappearance of Ms. Barrett, and his one-time girlfriend or something of that nature has pled guilty to tampering with evidence and has agreed to testify as it relates to the disappearance. Well, there were motions hearings held some 2 weeks ago, and one of the motions filed by the defense was for a suppression of any statements made by Mr. Frazee to the Department of Human Services because their position was that there was a state actor. Mr. Frazee was, in fact, in custody. He was actually in the Teller County Jail. And therefore, since you had government action that implicates the Fourth Amendment, that the Department of Human Services investigator should have advised Mr. Frazee that something could be used against him. Now, apparently, just prior to meeting with the Human Services people, Mr. Frazee was meeting with his attorneys. I would have hoped that he would have said, do not talk about anything with the Department of Human Services, because anything you say to them, they are automatically going to turn over to the prosecutors. I tell that to clients all the time. In this case specific, but as a general rule, don't talk to them until you talk with an attorney, okay? So the issue in this particular case was that Mr. Frazee was in custody, and that the woman from the Department of Human Services was there to basically do some background interview to see about placement of the 14-month-old child that was basically in the custody of Mr. Frazee at the time of his arrest. Then, of course, obviously when somebody gets arrested, the state comes in and says, we're going to take care of this child, but they always try to place the child with a family member if possible and not send it to a foster care or some sort of environment as well. So the investigator goes and speaks with Mr. Frazee. She goes through a list of questions that's normally asked on any other case. She wasn't particularly, according to her testimony, doing anything out of the ordinary routine. There was no coordination with the Teller Sheriff's Department as to any questions to ask or anything along those lines. Had there been that coordination or been some evidence of that, then I think it perhaps would have been a different ruling, but that's the way it is. Now, one of the issues of the particular case was the fact that Mr. Frazee was in custody, and you have government action. Why was there not an advisement of Mr. Frazee regarding this? He's in custody, right? Well, guess what? If you're in custody, yes, you're in custody in jail. If you're in prison and you're charged with a crime, that doesn't necessarily mean that they have to advise you of your Miranda rights because you're obviously in custody. So the court went through an analysis here in Mr. Frazee's case, went through the analysis that said, well, yes, in determining whether an inmate has been restricted as to require an advisement of Miranda rights, there's 4 factors to be considered: the language used to summon the individual, the physical surroundings of the interrogation, the extent to which he is confronted with evidence of his guilt, and the additional pressure exerted to detain him. And the court went through, in this particular case, it was the Denison factors. And then this is not all inclusive, but the court stated that the inquiry whether an individual has been further restricted to such an extent as to be deemed custody for Miranda purposes. Other circumstances a court may consider include the time, place, and purpose of the encounter, the persons present during the interrogation, the words spoken by the officer to the defendant, the officer's tone of voice and general demeanor, the length and mood of the interrogation, the placement of any limitations of movement or other form of restraint from the defendant during the interrogation, and the officer's response to any questions asked by the defendant, any directions given to the defendant during the interrogation, and the defendant's verbal or nonverbal responses to such directions. Ultimately, the court went through that analysis and said that everything that the Department of Human Services investigator had done was, in fact, not related to this overall legal purpose related to his case, but simply for the placement under the Children's Code, and therefore nothing is wrong. Mr. Frazee gave some statements regarding arrangements that had been made regarding the child as it relates to Miss Barrett's disappearance. And the court said that was all coming in because this was just a routine type of interview that was done under the Children's Code. There was also an opportunity where Mr. Frazee could have refused to go there. He could have ended the interview, but he was polite. He was courteous. So was the interviewer. She knew nothing about the underlying facts of the criminal case, and therefore the judge is allowing any of those statements that he came in to be used against him. Now, obviously, the defense was moving to suppress those statements, not just because they were made in violation of Miranda. They're trying to get those out because they don't want them to come in as evidence. It was kind of a Hail Mary, but good effort on their part. They at least got some information that they can use at trial to also cross-examine this witness. And the prosecutor gets the benefit of bringing this evidence in a trial. They see the evidence, how the witness presents on the witness stand. So everybody really got something out of that hearing. So I hope that wasn't too long of an explanation of Miranda, as well as applying it to one of the cases that we're actually following here on Crime Talk. We hope that you will like the video, hit that subscribe button if you have not done so already, and hit that bell of when you will receive notifications of when we put out new content or go live. We have a bunch of links below to our Facebook page, our Instagram page, coming Patreon page, as well as scottreisch.com, where you can sign up for our newsletter. Hope you take the time, take a look at those links, and please sign up. Have a great day, and can't wait to see you until next time on Crime Talk.